Okay. You say in that box, I'll read it separately and I'll argue. I will find you admonishing the engagement of work streams, you say.
Sorry,
Admonition against.
Mr. Semenya, repeat yourself. I didn't hear you, sorry.
Mr. Dango, I'm saying I should look to that box, which is at the top of 275. And you say to me that reading that, I will gain a clear message that you spoke against the establishment of the work streams.
Mr. Semenya, your question was the value of the work streams and the content issues?
No. Maybe you misunderstood the question.
I misunderstood you, sorry, sir.
If you pointed us firstly to this block, and my question to you was, please tell me where in that block you are speaking against the engagement of the work streams. You're able to do that?
Sure. This document is a document that I make reference to in my email to the minister, which you just canvassed me about. It is this document that I refer to when I tell the minister that the parallel briefing and decisions coming to her is not helpful in the context of the government task team seeking to find an urgent solution. So this is the document I am referring to, and in my affidavit I make it quite clear.
Okay. We know the work streams get...
Just a minute, Mr. Smith. While somebody is assisting me, Mr. Semenya, just to make sure that I'm keeping pace, I thought you had said to the witness, the only issue you had about work streams was the manner of reporting. You did not express yourself. You did not have any other concerns about the work streams other than the manner of reporting. Is that how I understood the question?
That is the question.
Flowing from that, unless I'm disillusioned, I thought the witness then said, no, I did also raise some concerns about the work streams. And I have to be corrected if I'm wrong. I understand the reference to the box referred to on page, I can't remember the page.
275.
Yes, to be demonstration or expression of some concerns about work streams other than mere reporting processes. Is that how I understand? Do I misunderstand you, Mr. Dango?
No, Judge, you understand my answer, because in essence, my letter to the minister on the 25th of January complained about the fact that as we as government are discussing the solutions, she's getting a different report without my input, without the CEO's input, without the Director General of National, anybody in the government technical task team. A briefing from Zodwa Mvulani was part of our discussions, and in the content of that briefing document is going against issues that we are busy discussing. The content, so it's not just the manner in which it was done without our knowledge, but it also talks to the content of what is being conveyed to the Minister of Finance a day before the government team will report back to us. So in the midst of the discussions, Ms. Mvulani was integrally part of the new process and chose to report something else to the Minister without informing me, without informing her direct supervisor, the CEO, about what was going to be the content of this briefing note. And I raised it with the Minister and I said it's unhelpful.
I hope it doesn't get more complicated.
I must give it my last attempt.
I don't know why, Mr. Semenya, because I personally have no problems with the evidence which the witness is giving. I think I follow what he's saying.
And before November, December, January, was there any other SASSA process in place meant to achieve the promise made to the Constitutional Court that come 31 March 2017, SASSA would be paying the grants by itself?
Mr. Semenya, my view is that the Ministerial Advisory Committee and the work streams were in place in total for 2 years. There were work packages that SASSA were involved in, and based on the reports that I got, so the work streams the Ministerial Advisory Committee morphed into the work streams. The reports that they were giving us were emanating from what they had developed when they were Ministerial Advisory Committee members as well. What I got, and having been in that space even before the establishment of SASSA and understanding the transactional nature of SASSA as an institution, what I saw was that what they gave us was not helpful. It means that SASSA as a whole, including the work streams which reported to the minister, had not developed the kind of solutions needed to ensure that SASSA would become a paymaster at the end of April 2017.
Okay. The Ministerial Advisory Committee was put in place during Minister Edna Molewa's time, right?
No. There were two ministerial advisory committees. One was put in place by Minister Edna Molewa, and when Minister Dlamini took over from being Deputy Minister, she listened to my advice and the advice of the then DG of Social Development, Mr. Musi Madonsela, and the then acting CEO, Mr. Tukiko Bakari, to close down the Ministerial Advisory Committee because we, at that point, advised that it was adding no value.
The first idea about the work streams comes from the Ministerial Advisory Committee. Is that right?
Second Ministerial Advisory Committee.
Right. At that point, it was not your advice to the minister as a special advisor that this is the wrong way to go.
Because at that point I was excluded from participation, Mr. Semenya.
Excluded sounds a little hard.
It's meant to be.
Well, I'm trying to test even its cogency, Mr. Dango. Any letter written to you by the minister to say you should not attend any work stream work?
No, Mr. Semenya.
Not excluded by the bodyguards we are told about from these meetings, no?
No, Mr. Semenya.
No force of any kind used to you so that you cannot access the work of the work stream. Am I right?
Can I answer no, but with a context? That, as I explained earlier in my evidence in chief, the relationship between me and the minister was over the years that whenever she had a problem, an issue, the first person or one of the first persons she would come to for advice was me. On this issue, curiously, I was omitted from almost every meeting related to the Ministerial Advisory Committee and the work streams. The same applied to Sipho Shezi.
In short, you are never excluded from those meetings by the minister as far as you know.
I was excluded through the fact of not being informed of meetings or invited or being mandated to be part of those processes.
I'm asking, you're not allocating any blame on the minister, are you?
I'm just indicating that contrary to prior practice, on this particular issue, my view is that my non-participation was not an omission.
Yeah, I heard you say it was more by way of commission than omission. We'll get there. One of the principal concerns I hear your evidence to be is that there was no firm plan by the work streams to deliver on the promise. Am I right?
Yes.
Is it also correct that there was no firm plan by SASA executives to meet the 31 deadline?
Yes.
And its inability had nothing to do, that is SASA, had nothing to do with the conduct of the minister.
Mr. Semenya, if one appoints a work stream to the tune of close to 47 million in it and add that to the millions spent on the Ministerial Advisory Committee, one has to assume that there must be a level of responsibility for the outcomes of that money spent, especially in my view that if one is given a direct instruction and there is a letter where the minister writes, do not interfere with the work of the work streams that I've seen in the process of this discovery, there is a clear interpretation by the staff of SASA that they must not interfere with the work of the work streams. And in my view, this disabled the ability of the executive to do what they needed to do.
Okay. Now that you know from your evidence there was no firm plan by SASA executives to deliver on the promise, that's the evidence, right?
Yes.
All right. I'm coming to the next one which you seem to resist. They were not incapacitated by the minister not to have a firm plan as SASA executive.
If you are told as the executive, your primary responsibility, SASA's value chain is very simple. You do application management, you do approvals, and you do payments. If you are told that one component of your work, which is payment management, must be dealt with by a team that is solely responsible to the minister, that message is that is the team that will deliver on the promise. That team did not deliver on the promise.
And you exculpate SASA from not being able to pay 1 April 2017. You exculpate them completely.
I will not exculpate them completely. I think that they needed to be firmer, and they needed to do what Mr. Magwaza did as the CEO when he stepped in. Mr. Magwaza stepped in and started assessing what was happening, and that is when a lot of the conflicts came in. Mr. Semenya, you must remember there was a long period in which you had an acting DG who was actually supposed to be the CEO of SASA. You had an acting CEO who would not be able to challenge with the same level of confidence the instructions of the minister that Mr. Magwaza did. So that issue of that huge gap between when Virginia left and Mr. Magwaza was supposed to take over, that long period of almost disgovernance is one that cannot be left out of this inquiry.
Yeah, that disgovernance happens as a special advisor to the minister. That's when the disgovernance is happening, right?
Mr. Semenya, as I've stated, that the minister canvassed me on many things.
I'm saying that this governance was happening during your period as the special advisor to the minister, am I right?
Yes.
Okay. You say you're advising on policy and politics. Is that your area?
Well, my area is mostly social assistance, social development, policy development around social assistance, but also the minister asked me to do a lot of the political media, political engagement, so one would understand that the way the mandating environment in government works, that you are mandated by laws, policies, but you're also mandated by the political environment. And in developing those policies, I liaised with stakeholders in the political space, including civil society.
Work streams, is it policy matter, you'd say?
The work streams was an administrative matter.
About which you had to have nothing to do with it, am I right?
I wish I had something to do with it, Mr. Semenya.
Yeah, but on your own evidence, you're taking umbrage that you're not consulted about something that you say had nothing to do with your role.
Given the context and its significant impact, if we fail to pay on the 1st of April 2017, this is an issue that I thought the Minister should have involved me in more intensely.
And also you don't put that in writing to say, I have fundamental objections around this issue, Mr. Minister, all right?
I did not put that in writing until I took over as DG.
That's right. Now, the Minister did not resist the second model, I mean the proposal of November, December, January, involving the various stakeholders. Am I right? That's why you sent in the letter on the 25th.
The letter of the 25th was a summary of the discussions that the Government Technical Task Team has had. We had previous discussions with the Minister on it. The Minister did not say explicitly that he was against the open architecture model, but I do know that there was resistance to it.
Okay. Let's look at the timeline. Come July 2016, the work streams are appointed. Right? Right?
Yes.
At that time, there is no SASSA executive program ongoing to deliver the social grants. Right?
The work packages had by that time been, in my understanding from the evidence, been subsumed by the work streams.
No, before this.
Sorry, Mr. Dango, just remove your hand from the mouth. Thank you.
As at the date of appointment of the work streams, that is now July of 2016, there is no program by SASSA's executive to enable SASSA to make the payments come 1 of April 2017. Is that correct?
That is correct.
So the work streams are not coming as a parallel process at that time, am I right?
The work streams was coming in as the process.
It's the only process, correct?
Correct.
And so to August, and we can run up until November of that 2016, am I right?
You are right.
There's nothing parallel that is working the same effort which the work streams are doing, am I right?
Mr. Semenya, again, if the executive of SASSA is not included in the decision-making process and the work streams are developing a solution which in the end offered no solution and reporting directly to the Minister, it limits the ability of the SASSA executive to assess what needs to be done and do it properly. In essence, the SASSA executive were excluded from the process of coming up with a solution.
I have referred to various sessions which the work stream had with members of SASSA. I covered this with Mr. Magwaza, do you recall that?
Mr. Semenya, yes, I recall you talking about the steering committee.
Yes. You recall that?
Yes.
The steering committee would have had SASSA people in it, correct?
I don't know. I did not attend the steering committee meetings, and I can only see from who attended it that it included Zodwa Mvulani, and it also included Brenton van Vrede from the Department of Social Development and Mr. Magasela from the Department of Social Development.
By that, I want to suggest to you that the argument we will make is that the work stream did do work with SASSA executives around the work they were doing. You can't refute that, can you?
I can't refute that. At points they may be involved, but what I can ask is what was the ability of the SASSA executives to make their ideas known to the work streams about what can be done and should be done if the instruction is to not interfere with the work of the work streams.
So what happens until the appointment of the task teams or the the technical team. Up to the point of the technical team, there is nothing that SASA is doing that is being frustrated by the minister, am I right?
It's a gray area in essence when you appoint a work stream to do the work that SASA executives should be doing, and the lines of communication about what they are doing and the content thereof is not shared. It is not within the ambit of SASA to come up with the solutions as required. I experienced this when we set up the government technical task team. Even though we had set up a government technical task team that was coming up with solutions, the work streams were continuing to work in the same manner that they had worked on before I became DG, and were continuing to report in a way that undermined the work that we were doing as a government technical task team.
Mr. Semenya, I can confidently say that you are asking that question for the 5th time now. And I can tell you, this witness is not prepared to simply give you an answer as to whether or not SASA had nothing on the table without contextualizing it with reference to the work of work streams, and indeed even earlier. And he keeps on giving that answer, and you keep on asking that question, and I can tell you my judgment of his answer is that he is not going to give you a simple answer to that question without contextualizing it by first starting even with the advisory committee, work streams and the like, and then he ends up saying, because of those things, that was why SASA was disabled from putting on the table a plan to beat the 31st. We can ask that question many times. He will keep on saying that.
Yes, Judge, I note that. I may come to that result, Mr. Dango, differently. I'm going to have to try. As in 2016, July, it is your evidence that a program by SASA executives was being derailed.
Mr. Semenya, the quality of the work that was presented to me on the October 2015 to December 22nd of October, the kind of reports given to the Minister of Finance indicated that even the work that we were trying to do as an emergency measure was being derailed.
I try to confine myself to July, and I hear your evidence you're going to October. In July, there was nothing being derailed. Is that fair to say?
In July, the work streams were established.
In July, there was nothing derailed. Is that right?
Nothing obvious in terms of what was being developed by SASA at that point.
August, nothing derailed.
If one understands the fact that the work streams were now employed to do the work, then they had the responsibility to come up with a solution, and in the manner in which they engaged, if they excluded the SASA executive, I still maintain that they were disabling the executive from doing the work they need to do.
Okay. I'm going to argue ultimately that it is only in November, December, into January, that the technical team is proposing something different from the work streams.
It's essentially after the meeting of the 5th of October when I assessed the level of non-readiness based on the report by the work streams that I immediately, together with colleagues such as Mr. Magwaza and Mr. Shezi, engaged a number of stakeholders to develop a solution that would make sure that come April 2017 we are not, one, challenged legally by the approach proposed by the work streams, and two, we have a firm plan in place to put to the Constitutional Court so that they can give us permission to extend CPS for 12 months.
You also spoke about an outside source or another source that was advising the minister. That's a reference to what?
Mr. Semenya, was not going to go into that space of ESA, but if you want me to go there, I can answer those questions.
Well, that was your evidence, it was
Sure.
not mine.
The minister, if one looks at the interregnum in the period between the minister withdrawing the document that Mr. Magwaza had submitted to the Concord and the new approach a few days later, because she had to consult. The minister consulted with people outside of the department. We do know that one of the people that she was consulting with was the president, because the president called Mr. Magwaza and asked him why he is not at that meeting. I canvassed this with the DG in the presidency, who had no knowledge of that meeting but knew that it took place after the fact. In that meeting was the people that were advising the minister, that new legal advice that was not in a written form as asked by Mr. Maleka, that was in oral form, which is in the presentation of Ms. Umvulani, was canvassed by outside advisors at that meeting. And this is not a once-off issue. It happened time and again.
Okay, that's as lucid as I will get it from you. Now, when you say the work streams stymied the work of the SASSA executives, you're using that word in the same vein you have been using it to suggest that it meant SASSA could not do the work itself. Is that what you meant by stymied?
Yes.
Okay. And finally, nothing the minister says that the alternative of the technical team should not be pursued.
The alternatives in the technical team?
The alternative the technical team was suggesting should be in place, the minister did not resist that, am I right?
The minister resisted elements of what we had proposed. The first element she resisted was the time period of 12 months. The second element that was resisted was full disclosure to the Constitutional Court, so that the Constitutional Court gives consent for the process, so that it allows National Treasury to grant a deviation on non-emergency grounds. The route the minister wanted to take after the 21st of January and as presented to the Portfolio Committee was that we no longer needed to go to the Constitutional Court for consent. This was reaffirmed by Ms. Umvulani in her presentation. Secondly, that it would now put the emphasis on National Treasury to make a decision on deviation without the consent of the Constitutional Court, which had a risk to the central procurement system. And this was what the government task team had worked very hard on achieving, that we needed to do full consent, full disclosure, give a firm plan, and that firm plan limited CPS's involvement to 12 months. That changed subsequently, Mr. Semenya. That changed quite significantly. It had cost implications to the extent that we had to make sure that as an accounting officer, together with the National Treasury, we had to make sure that given that this decision has now been made, it can only be made within the existing MTF budget. The minister had resisted elements of it, and its significant implications for government as a whole and for our understanding of what our constitutional obligations were. And that is why I resigned, Mr. Semenya, because these issues were too serious to ignore.
Nowhere does the minister say there shouldn't be a full disclosure to the Constitutional Court, am I right?
The minister agreed with the new approach the night of the briefing, even though Zodwa Mbulani gave the presentation. There's no way Zodwa would have made that presentation without the minister's go-ahead. I had asked the minister and the co-chair, who was the chair of the portfolio committee, to ask all the SASA executives and DSD executives in the room at that point to leave so that we can actually have a closed-door discussion on this new direction. That was not allowed. The minister agreed with that issue the next day. I had tried to get the minister to at least go to the Constitutional Court to state the intention to negotiate with CPS around the issues of pricing and timeframes, which were now limited to 12 months with the help of the portfolio committee members, and that did not take place by the time we got to Scopa.
At no stage does the minister say there shouldn't be a full disclosure to the Constitutional Court. Is that correct?
If one reads the minutes of the meeting of the 22nd of February of the portfolio committee, one gets the agreement by the minister, by Zodwa, that we do not have to make full disclosure to the Constitutional Court. That is in the PMG report, which is in my bundle, and it's also in one of the Black Sash bundles.
It is one thing to contend that somebody held the view that it was no longer going to be necessary to report to the Concord. Quite another to suggest that no full disclosure should be made to the court. I'm confining myself to the latter. At no stage is the minister saying reports to the Concord should be incomplete or not complete.
The full disclosure meant explaining what the firm plan was, which was in the CASM document. The full disclosure meant also asking for the consent of the court, given the order of invalidity, to extend the contract with CPS for 12 months. The full disclosure also essentially then states that this allows for National Treasury to engage in the process of deviation. The change of that in stating that we don't need consent from the court because they has discharged the supervisory role was new. And in fact, it was one of the paragraphs we had to delete from the CASM document and the instruction from the minister. And if you read the two documents, you'll see that it was the previous paragraph 55 in CASM's earlier document. It's not part of our bundles. Apologies for that. So the idea of complying with the Concord full disclosure is something that bedeviled the relationship between myself and the minister, and it started almost from the time I got involved as DG. So the minister affirmed what Zodwa presented, that we did not need the consent of the court. All we needed to do was to inform the court through a supplementary report what SASA was going to do, and that's not full disclosure.
Ultimately, the report was filed with the court.
A supplementary report.
Yes.
Ultimately, it
Yes.
wasn't full disclosure.
Huh?
It was not full disclosure.
Even that one was not full disclosure. The supplementary report.
No, the document that we term as full disclosure was filed with the report with the court. It was filed on the 16th of February after a meeting of all the senior managers, including Zodwa Mvulani. The document, and after consultation in the previous week extensively with the minister and a new special advisor on the contents of the document, and after a thorough going through the document between myself, the minister, and Mr. Shezi and Mr. Magwaza previously, and on the instruction of the minister that a special meeting be held on the 16th, the minister withdrew what was ultimately, it was not filed on that day. Mr. Magwaza filed it subsequently, I think on the 27th of February. That document was again withdrawn by the minister, and a supplementary report was later filed by Mr. Magasela, which was not a full disclosure document.
To the extent that there would have been advice that a full disclosure should not be made to the Constitutional Court, that advice was never carried, did not carry the day, did it?
It did. The advice that the Constitutional Court had discharged its supervisory powers and therefore you did not have to make full disclosure or seek its consent was the subject of the discussion of the 21st of February and again presented to Parliament on the 22nd of February. That view held despite the fact that we felt, and I mean me, I mean the senior managers, that full disclosure needed to be done.
So that's a final answer. Ultimately, the court was not told a full story because of that advice which was given.
The advice that did not emanate from any of the senior managers within the department.
I don't want any ambivalence. You're saying, even as we speak, a full disclosure was not made to the Constitutional Court, in part because there was an advice that it has discharged its supervisory powers and therefore you don't have to go there.
Mr. Semenya, the document that we worked on as the senior management team was prepared based on the firm plan developed by the Government Technical Task Team. It was based on what the emergency regulations, the emergency measures should be, because we could not ask for an extension of an invalid contract without full disclosure and consent from the court. That is the legal opinion of 4 senior counsels that emerged. We developed a document on that basis, discussed it with the minister. The minister was unhappy with certain elements, including the paragraph that requested that the court reimpose its supervisory powers, given that all the goals were not met. The minister was also not happy with the fact that the document explicitly mentioned the post office and post bank. We took that out. And we felt that that met the minister's requirements. We then, as Mr. Magwaza in his evidence in chief stated, had it deposed, all the necessary legal issues dealt with, and asked the General Manager of Legal Services from SASSA to take it to the Constitutional Court as a matter of urgency. That is the full disclosure document that was withdrawn without informing us, with the minister saying she needed to do further consultations. Further consultations apparently did take place, but not with senior managers of the department. The new approach that says that essentially counteracted the need for a full disclosure document was presented to Parliament on the 22nd, and that is the view that he held. So the document that Magasela submitted was not a full disclosure document. The document that the senior officials in the department and SASSA wanted to depose and had deposed and was repealed, not repealed, but taken back by the minister, was a full disclosure document.
Those are the questions we have for the witness.
I have no questions.
No questions by Mr. Kesim and no questions by Mr. Horn. Did I forget anybody else? Except that you may wish to re-examine.
I would appreciate to re-examine, and just, I will not be long, Judge. It's just certain areas that we need some clarity. Mr. Dango, you referred to a CASM opinion. Is this the opinion in May 2016?
Well, there's the CASM opinion in May 2016, but there's also the full disclosure affidavit to be made by the Concord, which was also prepared by Senior Counsel CASM.
Is this the document that you refer to as the CASM document?
That's the one I'm referring to as the CASM document, which is the full disclosure document that we had prepared to take to the Concord.
When you say it was a full disclosure document, was it in the form of an affidavit?
Yes, it was.
When you talk about the Trengrove opinion, to which do you refer?
That is the opinion that that came just after October 2017.
And the CASM document, when was this provided?
I think that was the May 26th, with the CASM document, the affidavit for full disclosure, that we discussed in February 2017. I don't know when the work commenced, but it commenced immediately after the technical task team, which discussed until January 2017.
Now, I think you misunderstood me. I just wanted to know, when was the affidavit drafted?
The affidavit was drafted in February 2017. We went through it, we finalized it, we even through the General Manager Legal Services checked that whatever changes we made were acceptable to Mr. Kassam.
Now, Mr. Dango, this governmental technical team, when was this established?
The governmental technical team was formally established in January, but we had started working from November onwards.
Of which year?
2016.
And by whom was it established?
It emerged out of a discussion between myself and the Director General of National Treasury.
And what was the mandate of this technical task?
It was, as Mr. Magwaza stated, in the end to give us options that will ensure that by April 2017, that we pay the grants without any hiccups, including legal hiccups.
And what is the outcome of the governmental technical task team?
6 options were developed, discussed, thoroughly debated, and eventually option 1 was agreed upon. But option 1 was also agreed upon in the context that the firm plan would be that the future payment model will be within the national payment system, using the banks, the post office, and the post bank, which is now called the hybrid model that the Interministerial Committee is pursuing.
So as I understand, the governmental technical task team was tasked to find an emergency measure.
Yes, and the emergency measure in the context of making full disclosure also had to develop a firm plan.
And when you are taken to your email of which says 12 months, is this the governmental technical task team's emergency measure?
Yes.
Now, you were asked, was there any letter written to you to say that you were not to attend workstream committee meetings? How would you have known of workstream committee meetings?
I would have known of workstream committee meetings through an invitation, through an email, none of that which I received.
You were asked that it was only in November and December into January that the technical team was propositioning something different. Can you explain that in the context of its establishment?
The governmental task team was established based on the urgency we felt, given the fact that what we saw emanating from the work streams did not give us the solutions we sought. and that we risked, both from a operational level and a legal perspective, challenges to our abilities to pay. On April 2017, the governmental task team brought together all the key players in government that had the necessary expertise and regulatory authority to allow us to develop a short-term emergency model, but also develop the long-term payment model.
Now, it was put to you that the work stream stymied the work of SASSA, the SASSA executive, because SASSA could not do the work themselves. Could SASSA not do the work themselves?
Council, I believe that if one looks at the competencies of the people appointed to the work streams, and as I explained, this is a transactional organization. Its major focus would be on application management, approval management, payment management, that there was sufficient capacity within SASSA to improve on those capacities. If one looks at the workstream capacities, one of the work streams, two or three of the work streams, there were 4 work streams or 5 work streams, but it was only the IT work stream that essentially dealt with that transactional nature of SASSA's work.
Thank you, Mr. Dengo. Thank you, Judge.
Just for clarification, can I just point out that the Trangrove opinion is dated 27th October 2016, not 2017.
2016, yeah.
Dated?
27th October 2016. The witness inadvertently said 2017.
Thank you. I take it we are finished with evidence now. And maybe let's just tidy up 1 or 2 things. To reaffirm, well, first with the record. I take it that we shall have a proper record. And I requested that I be furnished with 2 hard copies of the record. One will be a record which I'll keep very safely, which I'll have to transmit to the Registrar of the Constitutional Court for safekeeping. And the other will be the one that I'll use to work out my report. I may scribble some notes and so on and so forth, but there must be a very clean, untouched record reserved for the court. The record better be as good as it can be. Now, we remind ourselves that we said we would file heads of argument, or in fact, for that matter, written argument. By which date? Is that 2nd March. And again, please everyone make sure that I receive their submissions in 2 hard copies. And yes, you all file simultaneously if need be. But the 2nd March shall be the last date. And then, is it so that we have agreed that we will come and hear oral submissions on the 19th of March? And I may have to give further directives in that regard, particularly with regard to time frames. I would not want to unduly restrain people, but I said it almost as an aside, that perhaps not just heads of argument, but if possible, written argument. Obviously, there's a distinction. The view being that come the 19th of March, you will only dwell on some of the most prominent points or such points as you would feel you had left out. But maybe, of course, especially because you are going to file not in sequence, not in response to each other, there may well be a real need to speak to the submissions of the other person to which you would not have been able to speak in your own written submissions. So we'll have to make allowance for that as well. But I'm sure we'll find enough time. Again, if need be, we may have to go into the early evening on that day, but we will have to finish on that day. Is that acceptable to everybody now? Can I adjourn on that basis, please? Thank you very much. Thank you, everybody.